Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installation into our Anti-Federalist Papers series going on number 58. So if you haven't gone back and watched 1 through 57, I would highly encourage you to do so, because understanding the understanding the Anti-Federalist Papers and the Federalist Papers will provide you a very well-rounded understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. The version I'm using is provided by the constitutionalistsociety.com, but there are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both formats. And while you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 58 is titled, Will the House of Representatives be Genuinely Representative? Part 4, a continuation on the Federal Farmers Papers regarding the House of Representatives. Another reason it's so important to go back and watch all of the Anti-Federalist Papers rather than cherry-picking and jumping around. Excellent. So part 4, he says this, the Federal Farmer. It is said that our people have a high sense of freedom, possess power, property, and a strong arm. Meaning, I presume, that the body of the people can take care of themselves and all their rulers, and therefore, particular provision in the Constitution for their security may not be essential. When I come to examine these observations, they appear to me too trifling and loose to deserve a serious answer. This is in direct refutation to what Alexander Hamilton said in one of the latter Federalist Papers when he was responding to the decrying for a Bill of Rights to be included in the U.S. Constitution. He said, it's completely redundant because all of the rights of the citizens are inferred in the preceding 7 articles. Thomas Jefferson, even James Madison, they said openly, that's a baloney argument, not remotely true. If we're going to do this, we need to include a Bill of Rights. Which is funny because Thomas Jefferson later argued that, in fact, I digress. That's for a different lecture. Back to the Anti-Federalist Papers. To retaliate for the smallness of representation, it is observed that the state governments in which the people are fully represented necessarily form a part of the system. This idea ought to be fully examined. We ought to inquire if the convention have made the proper use of these essential parts. The state governments, then, we are told, will stand between the arbitrary exercise of power and the people. That's a direct refutation to what Madison said. He had said, I think in the Federalist Papers 50s, in the 50s number, he had said the state governments, if the federal government does go awry, does become too ambitious and energetic, the state governments will serve as an interdictor, as a barrier between the federal government's abuses and the citizens of their states. Did that come true? No. Madison openly admitted in his later papers and his later pennings that he made many foolish and naive mistakes when helping draft the U.S. Constitution. But back to this. This idea ought to be fully examined. We ought to inquire if the convention have made the proper use of these essential parts. The state governments, then, we are told, by Mr. Madison, will stand between the arbitrary exercise of power and the people. True they may, but armless and helpless, perhaps, with the privilege of making a noise when hurt. This is no more than individuals may do. Does the Constitution provide a single check for a single measure by which the state governments can constitutionally and regularly check the arbitrary measures of Congress? No. Congress may raise immediately 50,000 men and $20 million in taxes, build a navy, model a militia, etc., and all this constitutionally. That's exactly what happened under George Washington, 1795, the Whiskey Rebellion, when Pennsylvanians, doing this very thing, refused to pay an unconstitutional, abusive tax. George Washington, with 10,000 soldiers, if I remember correctly, went to Pennsylvania and forced at gunpoint 500 Pennsylvanians to comply with an unconstitutional, unrepresentative, abusive tax. How ironic is that? Not even Washington, supposedly the best candidate to be king, could not resist the temptations of power, the temptations and the allure of tyranny. And we know for a fact that Washington realized it was a bad, incorrect, unconstitutional thing to do. We know that for certain because he pardoned every single person involved in the situation. He knew what he did was wrong, but he did it anyways. Congress may arm on every point, and the state governments can do no more than an individual, by petition to Congress, suggest their measures are alarming and not right. I conceive the position to be undeniable that the federal government will be principally in the hands of the natural aristocracy, and the state governments principally in the hands of the democracy, the representatives of the body of the people. These representatives in Great Britain hold the purse and have a negative upon all laws. We must yield to circumstances and depart something from this plan and strike out a new medium so as to give efficacy to the whole system, supply the wants of the Union, and leave the several states or the people assembled in the state legislatures the means of defense. It has been often mentioned that the objects of Congress will be few and national and require a small representation, that the objects of each state will be many and local and require a numerous representation. This circumstance has not the weight of a feather in my mind. It is certainly inadvisable to lodge in 65 representatives and 26 senators unlimited power to establish systems of taxation, armies, navies, model the militia, and to do everything that may essentially tend soon to change totally the affairs of a community, and to assemble 1,500 state representatives and 160 senators to make fence laws and laws to regulate the descent and conveyance of property, the administration of justice between man and man, to appoint militia officers, etc. It is not merely the quantity of information I contend for. 2 taxing powers may be inconvenient, but the point is Congress, like the Senate of Rome, will have taxing powers, and the people no check. When the power is abused, the people may complain and grow angry, so may the state governments. They may remonstrate and counteract by passing laws to prohibit the collection of congressional taxes. But these will be acts of the people, acts of sovereign power, the dernier resort, unknown to the Constitution. Dernier, not dernier, not French. The dernier resort unknown to the Constitution. Acts operating in terrorum, acts of resistance, and not the exercise of any constitutional power to stop or check a measure before matured. A check properly is the stopping, by one branch in the same legislature, a measure proposed by the other in it. In fact, the Constitution provides for the states no check, properly speaking, upon the measures of Congress. Congress can immediately enlist soldiers and apply to the pockets of the people. These few considerations bring us to the very strong distinction between the plan that operates on federal principles and the plan that operates on consolidated principles. A plan may be federal or not as to its organization. Each state may retain its vote or not. The sovereignty of the state may be represented for the people of it. A plan may be federal or not as to its operation. Federal when it requires men and monies of the states, and the states as such make the laws for raising the men and monies. Not federal when it leaves the state governments out of the question and operates immediately upon the persons and property of the citizens. The first is the case with the Confederation, the second with the new plan. In the first, the state governments may be a check. In the last, none at all. It is also said that the Constitution gives no more power to Congress than the Confederation respecting money and military matters. That is baloney. That Congress under the Confederation may require men and monies to any amount, and the states are bound to comply. This is generally true, but I think that the states have well-founded checks for securing their liberties. Exactly. I admit the force of the observation that all the federal powers by the Confederation are lodged in a single assembly. However, I think much more may be said in defense of the leading principles of the Confederation. I do not object to the qualifications of the electors of representatives, and I fully agree that the people ought to elect one branch. If you haven't gone and watched the Articles of the Confederation lecture series, it was done in one video, I strongly recommend you to do it, because what he's talking about here is exactly what I share with other people, with other unionists online. They say, well, the Articles of the Confederation provided the same powers. Somewhat they're correct, mostly they're incorrect. Why? Because even though the Articles of the Confederation did provide for taxing authorities for the Congress, it was ultimately left to the states to implement it. That is not true of the U.S. Constitution. With the U.S. Constitution, if the federal government wanted to impose an unconstitutional tax, and the states tried to resist, well, the states could resist, but you have the federal government that has an army, that has a navy, now has an air force, has special forces, has its own tax enforcement agency, which is all completely unconstitutional except for the navy. but they had enforcement mechanisms. They have currently unconstitutional, illegitimate enforcement mechanisms. Well, those are unconstitutional, Caleb. It doesn't matter. The mediums for attaining those forces is provided for ambiguously in the U.S. Constitution. That's not true of the Articles of the Confederation. So if you had, for instance, an energetic Congress form under the Articles of the Confederation that says, we want to tax absolutely everything, he would be laughed out of the Congress because they'd say, sure, we'd make so much money with that, but you and what army? Are you going to go to each person, each citizen's door and collect taxes? Good luck. They couldn't do it. There was no mode. There were no avenues under the Articles of the Confederation. Now, with the U.S. Constitution, when you have an energetic Congress, an energetic executive, an energetic judiciary that says, yep, we want to impose a tax on everything, they don't laugh the person out of court. They say, okay, how can we do this as quietly but as effectively as possible? Then you have the Branch Davidians, then you have Ruby Ridge, then you have all of these different instances of these illegitimate but funded by terms of the U.S. Constitution enforcement arms that then go slaughter, murder, and maim innocent civilians because they refuse to comply with unconstitutional measures. But because that avenue of illegitimate enforcement is implicitly provided for in the U.S. Constitution, I mean, you can complain, moan, and groan all you want about unconstitutional measures, but ultimately, there's still going to be a gun pointed to your head. That gun simply did not exist under the Articles of the Confederation. Back to the Anti-Federalist Papers. Further, it may be observed that the present Congress is principally an executive body, which ought not to be numerous, that the House of Representatives will be a mere legislative branch, and being the Democratic on ought to be numerous. It is one of the greatest advantages of a government of different branches that each branch may be conveniently made conformable to the nature of the business assigned it, and all be made conformable to the condition of the several orders of the people. After all, the possible checks and limitations we can devise, the powers of the Union must be very extensive. The sovereignty of the nation cannot produce the object in view, the defense and tranquility of the whole, without such powers, executive and judicial. I dislike the present Congress, a single assembly, because it is impossible to fit it to receive those powers. The executive and judicial powers in the nature of things ought to be lodged in a few hands, the legislature in many hands. Therefore, want of safety and unavoidable hasty measures out of the question, they never can all be lodged in one assembly properly. It and its very formation must imply a contradiction. In objection to increasing the representation, it has also been observed that it is difficult to assemble 100 men or more without taking the tumultuous and a mere mob. Reason and experience do not support this observation. The most respectable assemblies we have any knowledge of, and the wisest have been those, each of which consisted of several hundred members, as the Senate of Rome, of Carthage, of Venice, the British Parliament, etc. I think I may, without hazarding much, affirm that our more numerous state assemblies and conventions have universally discovered more wisdom and as much order as the less numerous ones. There must be also a very great difference between the characters of 200 or 300 men assembled from a single state, and the characters of that number or half the number assembled from all the United States. It is added that on the proposed plan, the House of Representatives in 50 or 100 years will consist of several hundred members. The plan will begin with 65, and we have no certainty that the number ever will increase for this plain reason, that all that combination of interest and influence which has produced this plan and supported it so far will constantly oppose the increase of the representation, knowing that thereby the government will become more free and democratic. But admitting after a few years there will be a member for each 30,000 inhabitants, the observation is trifling. The government is in a considerable measure to take its tone from its early movements, and by means of a small representation it may in half of 50 or 100 years get moved from its basis, or at least so far as to be incapable of ever being recovered. We ought, therefore, now to fix the government on proper principles and fit to our present condition. When the representation shall become too numerous, alter it. Or we may now make provision that when the representation shall be increased to a given number, that then there shall be one for each given number of inhabitants, etc. Another observation is that Congress will have no temptations to do wrong. The men that make it must be very uniformed, or suppose they are talking to children. In the first place, the members will be governed by all those motives which govern the conduct of men, and have before them all the allurements of offices and temptations to establish unequal burdens before described. In the second place, they and their friends probably will find it for their interests to keep up large armies, navies, salaries, etc., and in laying adequate taxes. In the third place, we have no good grounds to presume, from reason or experience, that it will be agreeable to their characters or views that the body of the people should continue to have power effectually to interfere in the affairs of government. But it is confidently added that Congress will not have it in their power to oppose or enslave the people, that the people will not bear it. It is not supposed that Congress will act the tyrant immediately and in the face of daylight. It is not supposed Congress will adopt important measures without plausible pretenses, especially those which may tend to alarm or produce opposition. We are to consider the natural progress of things, that men unfriendly to republican equality will go systematically to work, gradually to exclude the body of the people from any share in the government, first of the substance and then of the forms. The men who will have these views will not be without their agents and supporters. When we reflect that a few years ago we established democratic republics and fixed the state governments as the barriers between Congress and the pickets of the people, what great progress has been made in less than 7 years to break down those barriers and essentially to change the principles of our governments, even by the armless few. Is it chimerical to support that in 15 or 20 years to come, that much more can be performed, especially after the adoption of the Constitution, when the few will be so much better armed with power and influence to continue the struggle? Probably they will be wise enough never to alarm, but gradually prepare the minds of the people for one specious change after another, till the final object shall be obtained. Say the advocates, these are only possibilities. They are probabilities a wise people ought to guard against, and the address made use of to keep the evils out of sight, and the means to prevent them confirm my opinion. But to obviate all objections to the proposed plan in the last resort, it is said our people will be free so long as they possess the habits of free men, and when they lose them, they must receive some other forms of government. To this I shall only observe that this is very humiliating language, and can, I trust, never suit a manly people who have contended nobly for liberty, and declared to the world they will be free. Signed, Federal Farmer. Excellent. So that is all to be said in number 58. Quite a bit of potent sayings to be said in number 58. If you have any questions about what was said in 58, maybe questions about what was said in the preceding papers, or if there's a topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you all have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.